you're ready.
Go ahead and do that. Good evening. The Town of Los Gatos Planning Commission meeting of March 23rd, 2022 is now called to order. Director Paulson, would you please call the roll?
Yes, thank you, Chair. Commissioner Raspy? Here. Commissioner Thomas?
Here.
Commissioner Clark? Commissioner Tavana?
Here.
Commissioner Janoff?
Here.
Vice Chair Barnett?
Here.
And Chair Hansen.
Here. Okay, so I guess that takes care of that. And so before I'll continue running the meeting, I will turn the meeting back over to staff who will address the rules of decorum and civility for our town public meetings.
The public is welcome to participate in the meetings, understanding that the purpose of the meeting is to conduct the important business of the town in an efficient and effective manner. For the benefit of the entire community, the Town of Los Gatos asks that all speakers follow the town's meeting guidelines by treating everyone with respect and dignity. This is done by following meeting guidelines set forth in state law, in the town code, and on the cover sheet of the agenda. The town embraces diversity and strongly condemns hate speech and offensive hateful language or racial intolerance of any kind at board, commission, or committee meetings. Town council and staff are well aware of the public's right to disagree with their professional opinion on various town issues. However, hatred and bigotry statements are completely unacceptable and will not be tolerated in any way, shape, or form at board, commission, or committee meetings. All public comments at the board, commission, or committee meeting must pertain to items within the subject matter jurisdiction of the town and shall not contain slanderous statements, hatred, and bigotry against non-public officials. The town will go through the following steps if a disturbance results from a member of the public not following these rules. If participating remotely, town staff may mute the individual with an explanation for the record of why muting occurred consistent with this policy. If participating in person, the chair may call a recess for violation of this policy, resulting in the immediate cessation of the audio and video recording and the commissioners exiting the chamber or meeting room. Staff will determine if the individual should be removed or if all members of the public should leave, depending on the extent of the disturbance. In the event that all public members exit, only the press would be allowed back in the meeting. Once the individual or individuals leave, the commissioners would return to the chamber or meeting room and the chair would resume the meeting. Persons disrupting a board, commission, or committee meeting may be cited for violation of the California Penal Code, Section 403.
Okay, thank you for that. And so we will move on to public participation. As the Planning Commission conducts this meeting on behalf of the Town Council and the residents of Los Gatos, we encourage active participation, which is essential for democracy and critical to the work of this Planning Commission. There are two major ways to participate. First is written comments. Written comments about agenda items submitted prior to the meeting are always welcome and helpful. And then there's also oral communications. During this meeting, there are two opportunities for members of the public to speak. First is during verbal communications, where an individual may speak on any item that is not on the agenda. And then during the hearing of a specific agenda item, a member of the public may speak on that item that is on the agenda. When called to speak, we ask you to state your name and address for the record. However, you may choose to speak anonymously if that is your wish. And we do ask, however, that you limit your comments to 3 minutes. So at this time, we will go into verbal communications, which is where a member of the public may speak on any items that are not on the agenda. Director Paulson, do we have any members that wish to speak at this time?
Thank you, Chair Hansen. I don't see any hands raised for items that are not on the agenda.
Okay, then we will move on. And the next item on the agenda is the consent calendar. We have one item to be acted upon with a single motion. which is approval of the draft minutes of the March 9th, 2022 Planning Commission meeting. Does any commission member or member of the public wish to pull this item from the consent calendar? I don't see any commissioners with their hands raised. So I don't think we'll have anyone from the public. So seeing none, may I have a motion for approval of the minutes or the consent calendar? Commissioner Tavana.
I move to approve the consent calendar consisting of the minutes of the March 9th, 2022 Planning Commission meeting.
Thank you. And may I have a second?
I'll second the motion.
Okay, thank you, Commissioner Rasp. And so we will, are there any comments or corrections to the meetings from any commissioner's standpoint before we take our roll call vote? So we go through roll call vote and I ask you to vote yes, no, or abstain. And I will start with Commissioner Thomas.
Yes.
Commissioner Tavana.
Yes.
Commissioner Raspy.
Yes.
Commissioner Janoff.
Yes.
Commissioner Clark. I think that was yes. Okay. Vice Chair Barnett.
Abstain.
And then I vote yes. And so the motion passes 6 and no opposed and 1 abstention. So then we will move on to public hearings, which is agenda item 2. And that is requesting approval for construction of a roof sign on property zone C2 LHP APN 529-01-006. Property owner, Los Gatos Investments, LLC. Applicant is Montebello Market, LLC. And our project planner is Ryan Safdie. Are there any disclosures that commissioners have for this item? I don't see any hands raised. May I see a show of hands from commissioners who have visited the property? Okay, great. Thank you for that. And I understand Mr. Safdie will be giving us the staff report.
Yes, thank you. And good evening, commissioners. Before you is a proposal for a new roof sign at 9 and 11 Montebello Way. As you may have noticed, the subject property is currently under construction for tenant improvements for a new commercial market. The proposed sign would be located above the flat projecting awning, set 1 foot in from the front of the awning. The individual letters of the sign would be 18 inches tall, set on top of a 2-inch tall raceway. The letters would be 3-inch deep aluminum channel and painted dark blue. The sign would have a white acrylic face with internal illumination, where the letters would appear blue during the day and white at night. The proposed sign would comply with the maximum allowed sign area. Per town code, a roof sign requires an architecture and site application. Town code states that an arch and site application for a roof sign is only allowed if all the conditions of section 29-10-125-8 are met. The proposal complies with all these conditions except for A, which states that roof signs must be erected only on a roof whose pitch is at least 1 vertical to 4 horizontal. As the existing building has a flat projecting awning with no slope, condition A cannot be met without modifying the existing awning. That said, the proposed sign is a roof sign per town code. Town code also states that a roof sign may only be issued if findings are made that a wall sign is not feasible because the wall of the building is set back beneath and obscured by the overhang, and that the sign cannot be suspended between posts or columns supporting the roof. The applicant justified the proposed project and detailed how these 2 findings are met in their letter of justification, which is provided as Exhibit 8 or 6 of the staff report. Specifically, the applicant contests that a wall sign is not feasible as the building facade is primarily glass and cannot accommodate a wall sign, and that the sign cannot be suspended below the projecting awning due to visibility concerns associated with the building and location in relation to Town Plaza Park. Additionally, the subject property previously had an unpermitted roof sign back in 2014, which is also provided as Exhibit 4 of the staff report. Based on the discussion provided in the staff report, staff recommends approval of the architecture and site application for a roof sign, subject to the conditions of approval and required findings. This concludes staff's presentation, and we are happy to answer any questions.
Thank you, Mr. Safdie. And do any commissioners have questions for Mr. Safdie or staff in general? I don't see any hands raised. So then we will open the public hearing. and give the applicant up to 5 minutes to address the commission. This time of 5 minutes includes any and all speakers on behalf of the applicant.
Good evening, Planning Commission.
Thank you, Chair. Mr. Foley.
Can you hear me?
Yes.
Good evening, Planning Commissioners. Thanks for taking the time to review the application. We provided the letter kind of describing what we're looking to do here for this sign for the new Montebello Market project. Very excited about it. We think it's appropriate for the reasons stated in the letter and the reasons outlined by Mr. Safdie just now. We've spent a lot of effort and time with the project and with our architect, and particularly with our signage consultant, creating something that's really unique and interesting, and I think it's going to be a beautiful sign, kind of identifying a really great amenity that we're bringing to town in Town Plaza. There's some visibility challenges with that building from really kind of the core intersection there where we're trying to draw customers in from. So we think we've designed something really tasteful and compatible, and would hope that you can see it for what it is, for what we presented. And I'm happy to answer questions about what it says, what we're doing, how we came up with it, anything that you might be interested to know about how we got here, how we arrived here, but would appreciate an approval. We're hoping to open the business in 3 or 4 weeks, which is just about enough time to get started and get the sign installed. So I'm here to kind of answer any other questions you might have.
All right. And then is there anyone else that you want to speak on the behalf of the applicant? No. Okay. All right. So I will ask now if any commissioners have questions for the applicant. Commissioner Jana.
Thank you. Yeah, just one quick question. The concept is intriguing. I'm just curious why the word market isn't also incorporated into your signage, so people will understand from a distance that more clearly what you're offering.
That's a great question. Thank you for that. So we actually had a version of it that did have market in kind of a unique position there, incorporated with the awning. Unfortunately, it's just the constraint we're working with. Even the roof sign, my understanding, has to comply with the typical sign guideline square footage constraints. And so in order to get recognizable size for the lettering for the word Montebello, we just simply don't have enough square footage of signage left to include the market there. So our approach is going to be to maximize the Montebello. I think that going forward, yeah, I mean, whether it's referred to as Montebello Market, I mean, that's really the primary identification and will be, really the significant part of the branding. So we're comfortable with that. But yeah, like I said, the constraint was basically if we had to increase the size of the letters to really make Montebello visible across the park from the intersection through the trees and all that we lose the market part of it. Now we still have opportunities for some window signage on the glass and things like that. And don't have that finalized yet, but hopefully the verbiage or whatever we have there, maybe that includes the word market or other references that are, identifying what it is, and we'll go down that road at a later date.
Thank you so much.
Sure.
And do any other commissioners have questions for the applicant? Commissioner Raskin.
Thank you, Chair. Applicant, I noticed that this is to be a lighted sign. Can you tell me what your proposed hours of lighting will be? Is it only during the hours that the market will be open, or are you thinking of something else?
Another good question. I mean, I think that typically in other businesses I've operated, the signage would be only during hours of operation. When we get into the summer months, and initially our hours of operation are 7 a.m. to 7 p.m. I think we have approval to go with later hours. We'll see how that goes. And to the extent that we're open, say during the summertime at 9 o'clock or something like that, I think that we would illuminate the sign. But otherwise, for closing earlier, the sign probably goes off when the business is closed. And then in the morning hours, similarly, I think we're open fairly early. If it's dark, we want to have the sign illuminated to be able to have customers recognize, oh, they're open. We can go there early to get our breakfast or our coffee. But it's not anything that's going to be illuminated late at night.
Thanks for your answer.
Thank you for that. And that was a question I wanted to ask. So thank you, Commissioner Raspy. And do any other commissioners have questions for the applicant before we go to public comments? Okay, I don't see anyone else with their hands raised. So then now we will go to members of the public. Are there any members of the public that would like to speak on this item, which is on the agenda?
Thank you, Chair. I do not see any hands raised to speak on this item.
Okay, so then according to our procedures for these hearings, we would go back to the applicant and you have an additional up to 3 minutes to address any additional concerns or points that you'd like to make.
So thank you for your questions. I don't have any further comments.
Okay, that's fine. And so then we will close the public hearing and I will ask commissioners if you have any questions for staff, comments on the application, or wish to make a motion. Commissioner Raspy.
Thank you, Chair. I just wanted to note that the HPC reviewed this property sometime last year, I believe. The applicant was reworking the facade of the property, which included preservation of the awning, which I think was a mandate of the HPC. And I'm happy to see that they preserved that. And I think the sign is well integrated using the awning. And as a result, while I understand that this is a technical rooftop signage, it seems to me that from what I've seen, what's presented thus far, I think it fits in well with the design aesthetic of that building, including its historic nature. And I would be proposed to support the signage as proposed.
Thank you for that. Commissioner Janoff.
Yeah, I would echo Commissioner Raspy's comments and state that the classification of the awning as a roof is sort of an interesting one. They do call it the lower roof in the application, but staff calls it an awning. And when you look at the building, it doesn't really read as a roof. And so putting a sign of this nature on that portion of the roof, when it has a full wall of building behind it, really does read like a wall sign. So I don't have any issue with the signage. So I will be supporting a motion in favor.
Thank you for that. Is there anyone else that would like to comment on the question or make a motion? I'll weigh in and echo the comments that were made by Commissioners Raspy and Janoff. In addition to the fact that this site seems to justify the need for having the sign of this kind of nature, I also think that we have a situation with all of our businesses in Los Gatos where any kind of retail oriented business is having difficulties. And so we want to give them all the opportunities we can to succeed without stretching our town code too far, of course, but I don't think this does that. So I'm hoping that this is something that the rest of the commissioners will support. And with that, I will see if no one else has any comments, if someone would make a motion on this item. Vice Chair Barnett.
Yes, thank you. I move approval of architectural and site application S-22-010, excuse me. I can find that the proposal is consistent with the general plan. I can make the finding that the proposed project is categorically exempt under CEQA. I can make the finding that the project complies with the applicable commercial design guidelines. I can make the finding as required by section 2910-125 sub 8 of the town code for granting a roof sign. And the application approval is subject to the conditions in Exhibit 3 and the development plans in Exhibit 7.
Very good. Can I get a second on the motion? Commissioner Tavana.
Second that?
Very good. Are there any commissioners that would like to make any additional comments before we take a roll call vote? Vice Chair Barnett.
I think I overlooked the required finding that the wall sign that a wall sign or suspended sign is not feasible for the reasons set forth on Exhibit 2. I'd like to add that to the motion.
Okay, that's good. And does the seconder accept the amendment to the motion?
Yes.
Okay, then I think we are covered. So I will go ahead and take a roll call vote, and I will start with Commissioner Clark. Yes, okay, all right. Commissioner Tavana,
Yes.
Commissioner Janoff,
Yes.
Commissioner Raspy,
Yes.
Vice Chair or Commissioner Thomas,
Yes.
Vice Chair Barnett,
Yes.
and I vote yes as well. So the motion passes unanimously. And staff, are there any appeal rights for this action by the commission?
There are, thank you, Chair. Anyone who's not satisfied with the decision of the Planning Commission can appeal that decision to the Town Council. Forms are available online and in Town Hall, the clerk's office, as well as the Community Development Department. There's a fee for filing the appeal, and the appeal must be filed within 10 days.
Okay, very good. Thank you for that. And so now we will move on to item 3 on the agenda, which is a public hearing to consider amendments to Chapter 29 zoning regulations pertaining to tree protection of the town code. And it looks like our staff person is our town attorney, Mr. Schultz. So is there a staff report for this item, or are we just going to go with the information that's in the staff report?
I'll give a short staff report. Good evening, Chair and Commissioners. In 2015, the council adopted the tree protection ordinance. And then in 2020, it amended it to include amendments regarding exemptions for defensible space. In 2021 and 2022, the council listed as one of their priorities under the ordinances is to amend it again to address issues primarily related to the penalty section and any other sections that need to be cleaned up. And that's why it's in front of you. This is your opportunity to take a look at the changes that I've proposed and proposed any other ones that you feel are important. But before we get into that, I'd like to share my screen because based on a couple of comments from a commissioner and from Dr. Weissman, I've added a couple other ones. So they're not very extensive, but I'd like to share my screen and kind of take you through where there's just a couple other changes that you can follow along with. So I'll do that now. I can find out which one it is. Okay, it's sharing it. My screen's not moving up and down. Oh, there we go. Okay, there we go. Let me take us back to the top. You all see that? Okay. Let me get us back to the top. So the first thing that was mentioned was under our definition of damages, it said it means in any action undertaken which causes shortened term. And the question was, if someone might interpret that to be only intentional. And so we've added language in there that says intentional or negligently. And so that's just the difference there. And then also we added in the word, this includes but not limited to mechanical injury. And I had not put that in a previous draft because we didn't have a definition of mechanical injury. So if you look, I've added a definition of mechanical injury to mean injury done to a tree either intentionally or negligently that leads to deviation from normal growth or a damaged appearance or death to the tree. Common cause of mechanical injury are landscape maintenance equipment, staking, damaged vehicles, or vandalism. So that's the definition that I proposed there. I might still reword that a little bit. What I would say to you is primarily with some of these changes that I'm presenting now is just to see a placeholder for those and see if you agree that we should add that mechanical injury. And then I can always work on maybe rewording those because I had to do these kind of on the fly. The next one is a cleanup that I didn't see before. And we talked about removing was transportation of a tree. And it should always been transplanting of a tree, not transporting. You can't really get in trouble just for transporting a tree. And that was just a cleanup that we had missed since this was enacted 5 years ago. The next change, besides the ones that you've already taken a look at, is just a little cleanup in here. This had to do with trees that are illegally removed and what's the requirements if there's a stop work order. And this, we added in language, once this retroactive permit is issued and all conditions are fulfilled. I think it goes without saying, but it's okay to add that language in there, along with any assessed monetary penalties paid and replacements required completed. I think that was another one that Dr. Weissman had put into the addendum, so I've added that in there, that language. And that was it. So there's not too many other ones I proposed, just the mechanical injury and a couple of the other small little items. And I'm open for any questions or discussion, and we're looking for a recommendation to forward this for council for approval.
Okay, so thank you for that, for Mr. Schultz. And I will ask if any of the commissioners have questions for you or for others on staff. I see it looked like Commissioner Tavana and then Commissioner Chanoff.
Thank you, Chair. Yeah, just a quick question. And in reading through all this, it says based on the staff's experience in implementing the tree protection ordinance, I'm just curious why these changes are being proposed now. Was there any issues in the past couple of years that it was not enforceable and we need a stronger language? Can you elaborate on kind of why these changes are being made right now?
Yes, we certainly did. We had a couple of very large cases that it wasn't clear exactly what penalties we could impose and how long we could impose them, and the difference between damaged versus removed. It's very easy to assess the removal of a tree. You know, if it's removed and you had no permit, it's pretty easy what we could find them, although I did even add stronger language as to the process that you'd go through. But the big issue is when they're damaged, how do you assess that penalty? Because possibly a damaged tree can recover completely. So that's kind of where we came from. In that really high level case that we had, it was almost the exact same time we were proposing it in 2016 also. So that had a little bit to do with the inconsistency with it. We assessed 30,000 in damages, which is still a large amount. I think that to curb any removal of trees. But if that same case came forward, it would have been tremendously more than that we could have assessed.
Okay, and let's see, Commissioner Chanoff.
Yes, thank you, Chair. Two questions, Mr. Schultz. First, there are 4 sections in the revisions that talk about the penalty of revocation of a license, a business license, if it's a Los Gatos business. One of them says it's 1 year, and 3 of them don't say whether it's a 1 year or permanent. So sections 29.10.0965, paragraph 5 says 1 year, and then the section 29.10.1025, all 3 sections where you've added the penalty that it's silent as to the duration of the revocation of the license. So whichever way you're intending it to go, I think that should be consistent among the 4.
My attention was 1 year. I don't think anybody should be penalized for life over something that maybe they didn't know about. So it was 1 year. So we'll clean that up and make sure they're all 1 year.
All right.
Unless Planning Commission thinks differently.
Personally, I think 1 year is pretty substantial penalty, so I would not want to go more than that. And my second comment, it's I apologize, I didn't note the specific section, but you used the word accessed fine rather than assessed fine. So you could search for accessed and see if you meant to say assessed. I checked with my legal expert and to see if that was a legal term of art, and it wasn't familiar to him. So
it's a typo. So thank you. I will check for that also. Thank you.
All right. That's all. Thank you.
Okay, and I have a question for the town attorney. My question is this: there has been a significant increase in activity and enforcement on the part of the Santa Clara County Fire Department related to clearance of vegetation from homes, and so as we're and I do understand the intent of this ordinance is primarily against people that are going at developments and taking down trees illegally. But what I wanted to ask about is kind of the push and pull between people that are under pressure to get their trees trimmed so that there's clearance from their homes and not creating fuel for fires versus that are need to protect the trees in the tree ordinance. So I just wanted to see where the intent was on that.
Yeah, and that was some of the changes we made in the last go round in 2000 to specifically address that issue. And there is that exemption in there for those issues that need to have defensible spaces. So we went through that and provide that exemptions for anybody that wants to remove a tree because it's within the defensible space, and especially if it's someone that has received something from Santa Clara County Fire saying that they need to be removed. So we have that exemption in there. We haven't had that issue come up at all. So
okay, well that's good to hear.
And it's right in the intent part of what we changed also.
Okay, yeah, I just wanted to make sure that was on the table that people knew that had been thought about. So okay, Commissioner Jan, if you still have your hand up. So
I have another question that I forgot to mention. And it's sort of related to the point that you've raised, Chair. But the question is whether PG&E has right of way to remove any and every tree that they are inclined to remove relative to the power lines. My assumption is that they have carte blanche, but it's not mentioned. And it's something that we're experiencing because they've been on our property a whole bunch of times in the last few weeks. And so just wanted to know whether that needs to be clarified or mentioned, that PG&E can do what they want.
That's a good point, because people call us all the time and they are exempt from it, and we don't list that in there. So it's something that we could forward, or if you want to forward that as a recommendation on putting language in that would address public utilities being preempted.
I think that might clarify, and just in case you don't really want to lose some great tree in your yard, but PG&E says no, it's got to go and we don't have to get a permit. So
okay, all right, great. Commissioner Clark.
Thank you. I have kind of a thought and a question. These changes are pretty significant in terms of the penalties, like there being misdemeanors and larger fines and loss of a business license.
all of them.
So I just wanted to ask if there are plans for making sure that people are aware of this, and just in general to suggest that that's something the town does after this goes through.
Yes. So, we will have many more tools in our toolbox by making these changes. And it's really going to be up to whoever the next town attorney is. I still believe, though, firmly, and it's really the philosophical of the town attorney, because he's in charge of code enforcement. I firmly believe if it's removed without the permit, they should be fined very heavily, and that's where the 4 times come in. I do have a difficult time with someone who maybe negligently didn't know the permit, didn't know about pruning, and harms a tree to begin with, but maybe it will survive and maybe it will come back completely. And in those situations, at least if I was the town attorney, I would not be looking for heavy fines. I'd be looking for education. I'd be looking to see if that tree survives and monitoring it like we can do now. But that's just my personal philosophy. Maybe you will have a very heavy-handed town attorney that's next. And if in fact they're fining everybody because their pruning was just not completely legal under our town code, I'm sure council will hear about it, and there'll be future amendments to it. So it really depends on how heavy-handed are. We issue warnings. We really are code compliant, trying to really educate and get compliance as opposed to fining. We issue fines for leaf blowers or for other violations or noise violations, but only after it's been substantially in non-conformance with the ordinance. So in this case, I think it really does provide associate needed benefits. And that's where we see them on the large developments where they see that they might have, the ability to increase the value of lots if they remove trees illegally. And that's, I think, where most of ours come in. I can't think of a single, there might be one or two that we have actually fined for single family residential that were cut from the property owner. It's usually when they're trying to do something to, like I said, improve the value of their lots. And that's where a lot of this will come in very handy.
Okay, and it sounds like there's a lot of room for the town attorney to interpret what penalty there should be rather than just there being like this action equals this penalty.
There always is with
Got
all
it.
code enforcement complaints and actions. There's always a great leeway for the town attorney and the code compliance officer to decide what the penalty or fine should be.
Thank you.
All right, thank you for that. Commissioner Respi.
Thank you, Chair. As an attorney counsel, I couldn't let this document go by without trying to put my own pencil on it. So I apologize in advance. Just two comments, though. One is a follow-up to Commissioner Janoff's comment regarding the revocation language, and to the extent that you've clarified it's going to be revocation for 1 year. I'm just curious, do you think suspension rather than revocation might be a better term for that? I don't practice administrative law, but it seems to me that revocation has almost a connotation of a permanence versus maybe.
I absolutely believe that's an excellent suggestion because actually through revocation, you probably have to have a separate hearing. So although I've put that in there, you couldn't just write someone saying it's been revocated, but you certainly can suspend a business
I think
license.
that is right. There might be a vested
Yep.
right if you'd have to go through some kind of due process before you could revoke it.
Yeah.
Thanks. And then just one sentence that to me is worded in a way I'm stumbling on it. If you can go to the last sentence of section 29.10.1010, and we're talking about pruning and maintenance. And the sentence reads examples of.
Hold on, let me get there. 1010. Okay.
So the sentence reads examples of detrimental action which are prohibited may include cutting, poisoning, burning, etc. Reading that quickly, it almost sounds like cutting could be a prohibited action in and of itself. And so I thought maybe a different way of phrasing that would be examples of actions which are prohibited when they are detrimental to trees may include blah, 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 etc. Just
Okay.
by way of clarification. A suggestion only, take
No,
that as you will.
I agree, because cutting in and of itself may not be detrimental.
Yeah, just to clarify. Thanks so much.
Mhm.
And I'm sorry, one last change. To the extent you were going to use the word then suspension instead of revocation, I think you'll have to amend the enforcement, the remedies language to use the suspension language as opposed to.
As always.
Right, thanks.
Very good. Well, thank you for those wonderful comments and adjustments that you're recommending. I have a question for the town attorney before we ask for public comment. And that is, we did receive in the addendum a letter from Dr. Weissman, and I saw that you had incorporated some of his comments into the draft that you went over with us. Is there anything that you left out? Because I need to ask the question because I would otherwise ask the commission, do we,
I think-
you
I
need to accept? Yeah.
So as far as what he submitted to the planning commission, those have been incorporated. I know Dr. Weissman had other issues that may or may not have been incorporated. He still has issues regarding clarifying the same issue that I still wrestle with a little bit, is that difference between removal and a tree that is damaged. And he was actually, asking earlier, I don't know if he was, whether this should be continued so that he could work further on it. I don't agree with that really being, unless planning commission wants to, about continue it. It would be, to incorporate all the changes that's been suggested tonight by planning commission. And if Dr. Weissman has any more specific ones, but I can always still work with Dr. Weissman before it gets to the council to make any other changes. It's not like if you make any other changes between planning commission and council, you can't allow those to happen. So I would probably, suggest you ask Dr. Weissman that question of what other issues he has and whether whether he thinks it's best to move this to council. My concern with council is you certainly aren't going to have the ability to get to it in April with, general plan and everything else going on. I will be leaving in May, and I thought it would be good to finish this one up before the new town attorney comes in.
Okay, thank you for that. Commissioner Thomas.
Thank you, Chair Hansen. I did have one question, and this kind of goes back to Commissioner Clark's question about when you, as a single, if you remove a tree for the replacement tree, so this is in section 2910-0985, there is a, like, in lieu of being able to replace trees on the property, you can make a payment to the town council to, help the urban forestry program, et cetera, et cetera. It does say shall, and I know that language came up a lot when we were doing the general plan stuff. Is that like discretionary enough that if it was like a large burden on a family, I know we're like really trying to diversify people living in Los Gatos, and if that was going to be, if someone had to remove a tree for a purpose and pay for the permit process, go through the whole thing, and then they're going to get like hit with now you have to make a donation to that. That could, encourage people to try and like avoid going through the correct process, and could be a larger burden on some families or individuals living in town. So is that like a discretionary thing that the town attorney will be able to?
No, wait, if it says shall, so that's good language that we might want to amend in your motion to make it not as restrictive and give us the ability to make that determination.
Okay, because I just do think that there should be some discretion, because for some people that could be, I don't know how, it just say like shall be paid to the town tree replacement fund, but it doesn't really clarify the amount. So it does say by the town council. I don't know. I think that I'm curious what other people say, but that seems like a little bit of an equity issue for me.
Director Paulson has his hand up.
Yeah, so I'll just offer a few more comments on that topic. So, it really is it's an or. So either you plant the trees that are required, or you have to pay into the in lieu fee fund. And so that's how, if you're unable to, sometimes we have a large number of trees that are required based on our replacement schedule, and you physically can't put that many trees on there. So, when they can't put the trees there, or there's some other exceptions in the notes down below, that then they have to pay that fee. So that's where that issue lands, and that's been in the town code for quite a while, even before the somewhat more comprehensive overhaul in 2015 that was done. Okay,
Commissioner Janoff.
Thank you. Yeah, I think it's a good point regarding equity, but I suppose that any individual or entity that is being fined or is being levied an in lieu fee could petition someone in town for relief if they had some sort of a hardship. So maybe Director Paulson or Mr. Schultz, you could comment whether there's recourse should that be the case.
Yeah, there's always recourse for any of the penalties that we assess. And I think, well, I guess you guys haven't heard one in a long time, but I was thinking of the historical, when there's demolition done without approval and there's the penalties, they get appealed to either you or to council. So on the same token, if there was a penalty that was assessed here, it can be appealed.
All right, great, thank you.
Okay, Vice Chair Barnett.
Yeah, question for Mr. Schultz. In Mr. Weissman's first recommendation, under the definition of damage, he wanted to include possible long-term injury. And I didn't see that in the red line that you showed us.
Yeah, I couldn't get to that term possible and trying to interpret what possible means. And that's why I left it out.
Okay, very good. Thank you.
Okay. right, good. So I do want to make sure we take public comment. We don't have a lot of participants, but I do see Dr. Weissman is in the audience. And so I will open up the public comments portion. And so if there's anyone from the public that would like to speak on this item that is on the agenda, and I do see Dr. Weissman has his hand up. So why don't you go ahead?
Can you hear me okay?
Yes.
Okay, thank you. A lot of my comments have already been covered, so that's great. These revisions submitted by staff have long been needed, and I commend Mr. Schultz for a job well done. The one area that I am still concerned with, and this could be certainly handled in the next couple of weeks, and that is the discussion that I would like to have with Mr. Schultz about replacement versus damaged, or I'm sorry, removed versus damaged. And that could certainly be done later on. I do realize that our town attorney will be leaving soon. And so I favor this solution. I would like to see the Planning Commission approve this draft as is with Mr. Schultz's add-ons to his add-ons and send it to the council. And as long as people are aware that a lot of the changes that the changes that have been asked for by the commission and some of the inconsistencies will be fixed between now and when this issue actually comes before the council. This way, our current town attorney, who knows this ordinance well, would still be around when council takes up this draft, hopefully in April. And that's all those are my comments.
Okay. And do any of the commissioners have questions for Dr. Weissman? Looks like our town attorney has a question for you.
If there's if there's no questions for Dr. Weissman, I have a response.
I don't see anyone with their hands raised, but I did want to thank you, Dr. Weissman, for, as always, for all of the time and effort that you put into helping us create better ordinances, especially when it comes to protecting the environment. So, town attorney, if you would like to go ahead, I don't see anyone else with their hand up.
So what I would suggest is, and this has been done many times, even when there isn't someone that says something, that there are still changes that are made between the time it goes to planning commission and goes to council. And so what I would suggest is, just like you got the current ordinance and a red line, there would be a current ordinance, there'd be a red line that was approved by planning commission, and then we'd do another red line to see what changes were made thereafter. So the council can really see exactly what you saw and what changes that were further proposed by either Dr. Weissman and myself. And so that's what I would propose that we do.
Okay, and so I don't think anyone else had any questions for Dr. Weissman, so I will close the public hearing portion of this agenda item and then go to the commission and ask if you have any comments or questions or are ready to make a motion. And what we're trying to do is make a recommendation to council, and that could include the version that we have and with the changes that we saw tonight from Town Attorney Schultz, it could be with the comments that were made today. And so all of those things could be in the motion. Commissioner Jana.
Yeah, before the motion, I just wanted to comment that I think the struggle that Dr. Weissman concluded with is a reasonable one to go from to differentiate removal or damage. I mean, you can see where an unsavory character might, oh, gee, it's damaged. Now we've got to remove it. Have no idea how that happened. So I think taking that a little bit farther makes good sense. And I'd be very comfortable having that happen with the town attorney and Dr. Weissman after or before it goes to town council after we presumably approve.
Even though we wouldn't see it again, but you're comfortable with that. Okay.
Yeah.
All right. Okay. Commissioner Tavana.
Thank you, Chair. In general, I'm kind of a little bit struggling with the language added to this ordinance. But given, I'm not sure what precipitated the need to have such strong language in the ordinance, but I do have a couple comments here. So I don't support suspending business license of the violating person / entity. I'm of the personal belief that it should be the onus of the property owner, or whoever hired the business, etc. So I don't know what we could do about that language personally. And also the threat of imprisonment is a little excessive, in my opinion, to put in the ordinance. Just some discussion items there.
Okay, I think that's a good comment. Do any commissioners have any thoughts on that? Commissioner Jana.
Yeah, I think that's a really good point, Commissioner Tavana. I can't think of a tree trimmer person who's come to do work for me who hasn't asked, what do you need to have done? I'm not taking trees down, so the issue of legal or not hasn't come into the conversation, but I think that's an interesting point. And we certainly wouldn't want a homeowner to hold the tree trimmer out or throw them under the bus for a decision that was really the homeowners. I don't know how you handle that, but I think it's a good point.
Very, very good point. And I will tell you that Dr. Weissman was the one that came up with the idea of suspending business license. We could two ways. If planning commission and recommendation is to remove it, then we'd remove it and council could still put it back in. Or we could tame it down a little bit to where it's a possibility, but not mandatory. And then your other comment regarding criminal penalties, they are severe in these sections. And again, I would never bring criminal charges. I'd only do civil for any of these, but that doesn't mean the next town attorney won't. So I mean, if the planning commission as a whole has those same issues of bringing criminal penalties against anyone that violated this, then that message should be sent to council.
Okay, thank you for that. I had a comment, and then I'll go to Commissioner Thomas. I think I agree with you, Commissioner Tavana. I think it's very unlikely that any business would lead the charge to take down trees. It would come from the property owner. So I think that whatever penalties are in the ordinance relating to the property owner who's going to be hiring the business to do the work on the trees is sufficient. So I for one would want to maybe tone that down. And I also think that the criminal charges seems a bit severe, especially since we have up to 4 times penalty for removing a tree. I don't know that we need to add on, but that's might just be me. Commissioner Thomas.
My question is related to what types of businesses have been violating. Have we had issues with violating and not getting the proper permits? Is it like contractors who are doing a lot of work removing trees when they're demolishing or building properties? Or is it like more tree pruning businesses people are hiring? For example, right now, we have some like volunteer trees in our backyard. They don't qualify as like trees yet. So I can remove them without a permit. I could just hire someone to come and do it, ask my cousin to come and do it who has a chainsaw, etc. But if I was remodeling my entire house and my contractor didn't follow through with the permitting, like I believe that those contractors, like in my opinion, if you're a licensed contractor working in Los Gatos, I do believe that you are responsible. Like that's part of me as a homeowner paying you to do services for me is knowing what permits to pull. So I do believe that in that case, if that is where the violations are happening, that suspended license for a year is necessary. If mainly the issue is me calling some guy and telling him to cut down a tree that ends up being needed to be a permit, that's a small business, I think that is a different story. So do we is there any background information about that we could have access to?
Great points. We have, since it was enacted, we assess the property owner. If there was going to be a fine, it goes against the property owner. We typically have not gone after the business. but this would give you another tool that you could have. But if you feel it's too harsh, one thing you could do is, I think the intent of it at least is if you've got the same bad character, if you've got the same pruning company that now 3 times has just failed to get a permit, and they've been warned and should know, and do enough work in town and didn't want to get one because they thought they could get away with it, then that's something that I think shouldn't be a license suspension. If it's the little guy, because every city's different, and he might not have known if he doesn't do business here, or is just starting out and is, like you mentioned, the small business, and now finds out that because of one mistake he now longer can do business here for another year. Seems harsh to me also. So maybe just language, toning that down or eliminating it, or toning it down to where it would only be after a certain amount of violations.
Okay, so thank you for that. Then I will go to Commissioner Janoff and then Commissioner Clark.
Yeah, I think that's a good direction to go. That gives us the strength of the language to be used when appropriate, but it isn't a requirement because there would be circumstances that it might not make sense. Also, I wanted to mention that working on historic preservation and those cases where there were violations of too much house removed, and so the penalties associated with that, they always went to the homeowner. They didn't go to the contractor, even though, as Commissioner Thomas says, the contractors really should know, and typically they know better than the homeowner, but it was the homeowner's responsibility to know. So that I think is a good point. But also looping back to what Commissioner Clark was suggesting at the outset, well, one of her comments was, what are we doing proactively to let town folk know that this is now a little beefier penalty? And I might suggest that there be something in the newsletter that comes out. Run a couple of articles that say something about how we treasure our trees and so on. And then the last comment I'll make is that there's an awful lot of people in town, similar to Dr. Weissman, who care passionately about trees, and it's sort of like a really, really big deal. We hear this all the time in Planning Commission when we're looking at a property where trees are going to be removed, and there's a lot of discussion. Less so now. We've had prior commissioners who are really tree-oriented commissioners. So it is a big deal, and I think the town really needs this kind of teeth, but it can be communicated up front so people are aware. And if homeowners know it's their responsibility, they're going to read that more closely or take note perhaps more closely. So I think all great comments, but I think that the sharpness of the penalty is important, as long as there's some way that we can implement it on a case-by-case basis.
Thank you for that, Commissioner Clark.
Thank you. I agree with a lot of the comments that have been made, and something that I think would make sense for things like the problem of a business. We do want to make sure that businesses aren't coming in here multiple times and doing the same thing without penalties. And so I think we could add verbiage saying after 2 offenses or something like that, to make it more targeted toward businesses that are actually doing it knowingly, rather than someone who just doesn't realize that this is the case. And then, yeah, I agree about the idea of making it more language that can be used when we need to, but there being a lot of leeway and also some protections for people who could be receiving these penalties, just because, like you said, we don't know who the next town attorney will be. And in general, this might be in place through a lot of different town attorneys. And so, yeah, I think we could strike a little more of a balance between protecting the trees and protecting the person or company on the other side. But overall, I do want to say thank you for protecting the trees. And I think that this ordinance is really, really important. And I'm happy to see it becoming a little stronger.
Commissioner Janoff.
Just one last piggyback. I wouldn't allow 2 warnings. I would say 1 warning and then go to penalties.
Commissioner Clark.
Yeah, I think 2 offenses, if that makes sense. So like do you think this is maybe too in the weeds, but a warning, and then if they've done another after a warning, then
what I'm suggesting is once warned, you don't do it again, period.
Yes.
You know, so
okay.
say whether it's an offense or a warn, people are going to know and that they don't want to do that again.
And I can pull some exact language. That's what we have in our leaf blower language is it's, yes, there's one warning, one notice of a violation you get. And then after that, then there's a fine. So we can incorporate that exact same language in this.
Great. Commissioner Thomas.
Are these proposed changes specifically for the suspension of the business license or for the homeowner fines?
Just the suspension. And I agree, though, we do need to do more social media and reaching out to make sure that, again, reiterate that you do need that permit. I think most now understand that or have heard about it, but just to make sure they understand the penalties have been doing it also. But no, I don't think we want a warning for a removal of a tree. It still needs to be compensated regardless if you knew or didn't know.
Yeah, okay, I agree. I just wanted to clarify. Thank you.
Okay, Commissioner Tavana.
Thank you, Chair. Instead of suspension, I don't know if the commission would agree to this, but potentially a fine for the business. I would hate to suspend a business from operating, from surviving, for making a mistake once, maybe twice, change in management, change in ownership. You don't know who's coming in and out of the doors or who's aware of what's going on previously. A fine is a adequate deterrent, in my opinion.
Thank you for that. Commissioner Clark.
I think that the idea is that it wouldn't be a mistake if they had received a warning, and that that punishment is targeted toward businesses that are doing it intentionally. And my concern with only having a fine is this is a problem we see in the world is people who are able to afford that just saying, I'll make more money if I pay the fine and keep doing this. And so I think that there probably are cases in which the suspension of a permit is necessary.
Okay, thank you for that. Commissioner Thomas.
I agree with Commissioner Clark's comments. I think that there are some people that could possibly operate under the assumption that they can just pay the fine and continue. And I don't think that's strong enough in discouragement.
Okay, any other comments on the issue that Commissioner Tavana raised? Vice Chair Department.
So I assume that these penalties would be levied by the Community Development Department. Is that correct?
Yes, they're levied by the Code Compliance Officer, Community Development Department, and myself.
Okay. So what would there be an appeal right by the contractor in the event of a suspension of license?
We certainly could put that language in there. As you see, there's already any interpreted may appeal a decision of the director pursuant to this division. So we do have appeal rights already in there. They don't specifically address the suspension, but it's any decision that's made.
And then just to blur the matter further, there could be some language to the effect that the code compliance officer shall consider what's fair and equitable under the circumstances, considering such factors as repeat violations, things like that.
And we have that in our code compliance manual that we did. One of the first things when I came in, we adopted a pretty extensive code compliance that talks about, what are the high priorities and low priorities for code compliance. And in there is those equitable decisions that you need to make based on the circumstances. So I don't know if I want to put in the code per se, but that's certainly, and even where it says, if the language is written the way I still interpret it, and I was just looking at it, but then I went down, it says, it shall constitute grounds for revocation. It doesn't say it shall be, it's just grounds for it. And it's grounds for suspension. But in my mind, I interpret that to mean there's still that ability to decide whether there should even be a suspension or not based on the circumstances.
Thank you for that clarification.
So it sounds like there is some discretion that can be involved in whether or not to apply that. You're on mute.
if we put the language in there regarding suspension instead of revocation, and we list the language like we have for the other ones with warnings, I think we're good to start with. And again, if someone's too overhanded, the council hears about it immediately. So we have to be fair, equitable, and make a determination on these fines and suspensions, because if you are overhanded, I'll tell you, I'll get the call normally around midnight.
Okay, Commissioner Jana.
Unless there are other comments, I'll propose a motion.
That would be great. Thank you.
All right, so I move to adopt the amendments to Chapter 29 zoning regulations, tree protection of the town code. I can make the required findings for CEQA, and I can make the required finding for consistency with general plan. And this motion includes changes recommended this evening with regards to penalties and other clarifications as noted on the record of tonight's meeting.
Okay, can I get a second? Commissioner Thomas.
I second the motion.
Okay, and then are there any comments or questions before I take the vote? Roll call vote. Yeah. Commissioner Tavana.
Just one quick comment in terms of, the penalties. When it comes to the town council, I would strongly urge to remove the threat of imprisonment over tree removal. I think it's excessive.
Okay, so I'm going to ask staff a question. So that would be an amendment to the motion because, or no?
I don't think Commissioner Devon is asking for an amendment to the motion. He just wants that in the record.
Okay.
Correct.
But I certainly in my staff report that goes to council mentioned that there was concerns on whether criminal penalties should be applied in this situation.
Okay, and I would echo the same, because I did make that comment earlier that I agree with Commissioner Devon on that point. And so if it goes along in the notes that go to council, then that's sufficient. Commissioner Jana.
And I would just say the maker of the motion would understand that that comment is a part of tonight's discussion. And I think there was general agreement that imprisonment was too severe punishment.
Okay. So I think that'll cover the concern adequately when it goes to council. Okay, so then I will go ahead and I will call the question, and I will start with Commissioner Tallis.
Yes.
Commissioner Tavana.
Yes.
Commissioner Raspy.
Yes.
Commissioner Janoff.
Yes.
Commissioner Clark.
Yes.
Vice Chair Barnett.
Yes.
And I vote yes as well. So the motion passes unanimously, and I will ask staff if there are any appeal rights for this recommendation by the commission.
Thank you, Chair. There are not, because this is a recommendation. It is not a final action by the client.
Okay, thank you for that. All right, so that concludes all of the major agenda items, and we will move on to the report from the Director of Community Development.
Thank you, Chair. A couple items, but I'll offer the opportunity, and if Ms. Armour is interested in providing an update on the general plan, otherwise I'm happy to do that. So it looks like she's turned the camera on, so I'll turn it over.
Thank you, Director. Yes, I'm here this evening to share a brief update about the status of the draft 2040 general plan. Tomorrow, we do expect to have the final EIR published online and distributed. It will be shared with Planning Commission, Town Council, and the public. We'll be sending out social media outreach, emails, and publicizing that. And this is in anticipation of bringing the draft general plan and the EIR for consideration by Planning Commission on the April 13th meeting of the Planning Commission. So we will include in the memo when we send this out to you tomorrow, a list of some of the documents that we recommend you get started on reviewing if you haven't already, and where they can be found online. So that you can prepare. We do anticipate a long staff report with a number of attachments with additional comments and information for you to consider that would come out on the Friday before the meeting.
All right. And
Great.
then,
Thank you, Ms. Armour. Thank you, Chair. I just had one additional item. I just wanted to let folks know that we will be having a community meeting next Thursday. And that is, we're using what's called the Balancing Act tool. It's an online opportunity for folks to help the town select sites for the sites inventory process that is part of the housing element. And so we will be providing some basic information and then also some instruction on how to participate in that opportunity. And then that information will be packaged up and then brought to the Housing Element Advisory Board on their second meeting in April. So we'll give folks a few weeks to participate in that. Obviously, it'll be online throughout the process, so we may get additional comments moving forward, and we'll just make sure that the different bodies, whether that's Housing Element Advisory Board, Planning Commission, or Council, continue to get that information up to a certain point. Thank you.
question for staff on your report of if members of the Housing Element Advisory Board and or the Planning Commission or other boards and committees want to be able to use the Balancing Act tool prior to the Housing Element Advisory Board meeting, that's not going to be for several weeks after that. What is the best way for that to happen? Would they need to attend the community meeting, or is there another way to engage the people that are on the boards and commissions?
Yeah, thank you, Chair. So ultimately, it's going to be online, so anyone can access it that has access to the internet. So anybody can participate in that. Obviously, the Housing Element Advisory Board will have further discussion about kind of what we've learned from that exercise, and then that will help inform the Housing Element Advisory Board as they make their recommendations. Once we get to the point where we have a sites inventory, we will then take that back to Town Council to have a check-in to make sure that they're comfortable moving forward with those sites. But it will be available to the public, and that will start, I think, it's either on the 1st or the 31st. I can't remember which day we're actually going to launch that live. And so that anyone will be able to participate in that opportunity.
And you're going to send that communication out through all the regular communication channels so that people are aware that that's an opportunity that they have regardless of whether they go to the community meeting or not, right?
Correct. And there will also be a video of the meeting posted on the website. So if someone isn't able to attend the meeting, then they can watch the video so they can get additional information on how to use that tool.
Okay. Commissioner Janoff has a question for you as well. So.
Yeah, this is a question for Ms. Armour. The links that we're going to receive this week for the general plan, approval of the general plan meeting for the Planning Commission, is that the complete list of attachments that we'll be getting on the Friday before the Planning Commission? So, I want as much time as I can possibly get with everything you've got to offer. So please.
Yeah, thank you for that question. What we're going to provide you tomorrow with the memo is going to be a link to where the final EIR is. The final EIR includes responses to all comments that were received on the EIR itself. In addition to that, there are a number of other documents that are already available online that we do suggest that the Planning Commission take a look at. So there's the draft 2040 general plan, right? That's a sizable document to be going through. In addition, there is the draft EIR, which it gets incorporated into the final EIR. The two together become the final EIR. And so all of that is available for you to review. In addition to that, at the joint study session that you had with Town Council on September 20th of last year, there were all of the public comments that have been received up until that point from the end of the GPAC's work from the May meeting up through that September 20th meeting. All of those public comments were attached to that staff report. And so you can go back and you can take a look at all of those public comments that were received over the summer and up until September 20th. Once we get to packaging and publishing and sending you the staff report for the meeting on April 13th, that will include additional information. So it'll include public comments received since September 20th. It'll include analysis, kind of a sorting of where there are specific recommendations on each of the elements. And it'll include some of the information that was specifically requested by town council when they had their second study session on this topic, asking for specific information and options to be provided to Planning Commission. So all of that is likely to be in that staff report the week before the meeting.
Okay, so lots to read that weekend.
Yes, absolutely.
And I would go as having been the previous chair of the General Plan Advisory Committee and also your chair of this year's Planning Commission. I strongly encourage all of you, especially those of you that were not on the General Plan Update Advisory Committee, to start reading now because it is a lot. And it's the document itself is pretty long. And then in addition to that, there's a lot of comments out there. And I would also encourage you to view the joint study session that was on September 20th, as well as the Town Council special session that they had in December, where they went over a lot of options about how to go through this process and are there things that that should be thinking about as we're doing that. So if you can review all those before the final thing comes out the Friday before the meeting on the 13th, that would be helpful. And then you'll have that much less to review because we will probably have quite a bit of public comments on the 13th. I would imagine. So, okay. All right. So then I think that's all for the report from the Director of Community Development. And thank you, Ms. Armour. Did you have anything else you wanted to add, Ms. Armour?
One additional thought that I did want to share. One of the things that we do recommend with a document of this size, where there will likely be some additional changes recommended by Planning Commission, that you won't just be recommending the 2040 general plan, but you will likely recommend it with some modifications. As you are working through the document and looking at the public comments that have been received so far, and then over the weekend before the meeting, if you have thoughts about changes that should be made that haven't been specifically spelled out in that staff report or its attachments, we strongly recommend that you write those up and send those into staff. You can send those into me or to Director Paulson, and we can incorporate those into an addendum report so that all of the commissioners have a chance to take a look at any suggestions, especially if they are small wording changes that you would like to recommend. Everybody then has that in writing in front of them, and it could be incorporated into a motion rather than needing to come back for further discussion later.
Thank you for that, Ms. Armour. And that is a practice that we were very particular about as we went through the general update advisory process prior to releasing the draft general plan, which is that it's very difficult in the throes of a meeting to process for our committee members or commission members, being yourselves, to process a whole bunch of new information and integrate it with everything else that you've received to date. So if it's at all possible to put comments in writing before, the other benefit to that is that it also becomes part of the public domain so that the public knows, that these are comments that are being made, and then they may choose to weigh in or on them or not. And then finally, I would also say, because we won't be meeting again until that time, that 35 meetings did go into the draft of the general plan. So I'll give the same advice I gave to the General Plan Update Advisory Committee, that every section of that document has been gone through multiple times by 12 of the brightest people that I've ever worked with in my experience in the town. So I don't foresee a need to do a whole lot of wholesale rewriting of the general plan. And you may all feel different, and you certainly have the right to comment that way. But I would if it gives you any comfort, let you know that a lot of analysis went into the draft general plan as is. So I'm hoping that we aren't going to have to make a lot of substantial changes given all the review that's already happened. Okay, So that with that being said, we do need to move on to the subcommittee reports. In addition to their service on the planning commission, every planning commissioner serves on a subcommittee, and that includes, in our case, the Housing Element Advisory Board, which is also the General Plan Committee, the Historic Preservation Committee, and then the Conceptual Development Advisory Committee. And I do believe we do have one committee report. I believe the Historic Preservation Committee met. And so if that's the case, Commissioner Raspy.
Thank you, Chair. Yeah, we had our HPC meeting this afternoon, and it was an agenda-packed meeting. I think it was the longest session we've had since on my tenure on the HPC. We had 7 matters there, 2 of which were requests to remove from the inventory. 1 was granted, 1 was not. 1 ground-up construction, and 4 requests for additions and changes. So I thought a very productive meeting. And then we also had public comment. A member of the public called in to note that several municipalities, including, I believe, Pasadena and perhaps 1 or 2 others, are evaluating the impact of historic preservation districts and ordinances on SB 9. And she encouraged town staff to take a look at those issues to see if that may impact Los Gatos and its implementation of SB 9. So that was HPC this afternoon.
Commissioner Clark.
Thank you. I just want to add one thing to Commissioner Raspy's report. One of the proposals that came forward was to change the materials of the trims for windows because a new one had become available called fiberglass clad wood. And the staff used it as a bigger discussion of what we want to see permitted in terms of materials. And we are planning to continue that discussion with more information on the specifics of those sorts of materials. And I think we'll have a discussion on whether that's what's important or if it's more important to focus on the appearance. And we've also discussed having some sort of in-person meeting, like a special meeting, to be able to actually look at those things, because it sounds like that's something the committee used to do.
Okay, very good. Thank you for that detailed report and for all the work that you do on the Historic Preservation Committee. And so then I will go to the last item on the agenda, which is commission matters. And since we already talked about the general plan, but we still have the opportunity if we want to bring up anything related to the commission. And I do have one thing that I wanted to bring up for myself, which is that Commissioner Clark and I attended the Planning Commissioners Academy in San Ramon last week. And it was a very interesting session, and we got a chance to network with the planning commissioners from San Jose and Campbell, as well as from other jurisdictions all over the state. And it was the first time that the meeting had been in person since before the pandemic. Last year, it was all done on Zoom. And I don't know if Commissioner Clark had any takeaways, but I had one very important takeaway, and that is be afraid and be very afraid of what's going on in Sacramento, because as onerous as all the new housing laws are that have already been approved, there are literally dozens, if not hundreds more coming down the pipeline. And it's all being driven by the desperation of the state government to see additional housing get built. And so as we go through the housing element process, it will be of critical importance to do everything in our power to make sure that we do make our RENA happen so that we don't lose local control over how we build housing here in Los Gatos. And it's bad enough to the point where my observation, I don't know if Commissioner Clark felt this way, but I told staff yesterday, I almost feel like CEQA could actually go away for housing because the state is so desperate, they don't want to slow down anything, even for environmental review. And finally, one point about the historic preservation, they did do a session on SB 9, and I do remember clearly they said that historic properties need not be subject to SB 9, but they did say jurisdictions could always make it more, make it easier than the law states. So that was my comments on the Planning Commissioner Academy. Commissioner Clark, did you have anything else that you want to go ahead?
Yeah, thank you. Yeah, so as Commissioner Hanson said, we attended the Academy last week, and it was really, really valuable to have it in person. And we were both able to do really valuable networking with other commissioners and staff from all over the state. So I was able to attend sessions on Planning Commission 101, Intro to CEQA, SB 9, Advanced CEQA, Streamlined Housing Laws, How to Prepare Findings and Conditions of Approval, City Finance, and upcoming legislation. And we also had 2 wonderful keynote sessions. And so it was a lot of information and knowledge, and I'm really excited to use this going forward. And one of my main takeaways was that our problems that we're facing are somewhat universal. Like all of these other jurisdictions are having the same struggles that we are and are asking the same questions. And so I think it really demonstrated the value of talking to other communities, and our networking with San Jose and Campbell commissioners was really valuable, because we were talking about sometimes you don't know even which of those cities you're in when you're driving around because they're so close to each other. And so I think that it provided an opportunity to start working together and having these conversations.
Thank you for that, Commissioner Clark. Did anyone else have anything for us? It looks like we all want to go home or be done. So I will thank you all for your service and your contributions to tonight's meeting, as well as your service on all of our subcommittees. And we will see you all on April 13th. And this meeting is adjourned.